Thank you so much. What do you know about Chautauqua?
Don't know much. I mean, I have this recollection. My father's a musician, and I think he may have been involved in it. I remember Chautauqua stuff around the house when I was a kid. This is in Toronto, Canada,
Right.
in sort of the late 50s, early 60s, but I don't actually know what. And I think I told them that I was coming to Chautauqua, and they just said, oh yeah, Chautauqua, you know, so that's about all I know about it, really.
We're delighted you're here. And how did you get into the business of international criminal law? It's not a normal path.
No. Well, my life hasn't followed a normal path, really. I went into law as sort of a late career. I was 29 when I started at law school, and graduated, and I guess got qualified as a lawyer in Canada when I was in close to my mid-30s. And then I just had an ordinary law practice, and I did some criminal law, but I wasn't dealing with international drug lords or anything. I was just dealing with shoplifters and prostitutes and their clients and stuff like that. And then went into academic life in the early 1990s. I had an appointment as a professor, and I taught criminal law at a university in Quebec. Always with the idea that I would eventually take over the teaching in human rights law. And then the International Criminal Tribunals started in 1993. And I hadn't followed and wasn't aware that anything was going on. I mean, now I know, and I can write about it, that from 1989 you had the International Law Commission had sort of been reactivated to work on on international criminal law and on a court, but I didn't know that at the time. And the first time I really became aware of this was in early '93 when the Yugoslavia Tribunal was being created. And then just sort of my combined interests in international law, criminal law, and human rights law just focused me on it, and I've never lost that focus.
Did you ever have, I know you've obviously met with all the various folks during that time period. Did you ever want to cross over the line from the academia and to say, hey, give me the reins, I'd like to be a prosecutor?
No, I don't think I ever would have seen myself as a prosecutor, although who knows, I can't say, looking back 15 years, that if Richard Goldstone or Louise Arbour had called me up and said, would you be interested in coming to work with me, that I wouldn't have jumped at the chance. I probably would have at that time. But I don't think then I barely registered on their radar screens. I was just sort of someone in the crowd who would, you might meet at a conference or something. Right. And it was really through, I think through my academic writing that I started to become better known in the field and became sort of a kind of a participant rather than just an observer.
Well, explain that a little bit more as a participant, observer. Your books, you've done over 20 books, well received throughout the academic and the professional community. But at some point, do they use you as a resource, the tribunals? I mean, do they come in and say, Bill, we got these particular issues, you've studied this, can you provide us some insight?
Not very often in a formal sense. More often I would be approached by defense lawyers asking to join in a case or to advise them in a case. And I would say that's happened more often, actually. And beyond that, I speak through the stuff I write, really. And so they will use the materials. They won't always, of course, they're prosecutors. It's an adversarial system. And so the stuff I write is it's academic, and so it's objective and neutral, and that means that someone in an adversarial system only finds it really helpful about 50% of the time.
So when you're helping the defense counsel in some form or fashion, either as a consultant, do they think you've changed your spots in the sense that you've now a resource to the defense vis-a-vis prosecution? Have you ever felt any sort of taint on that at all?
I don't know. I've been nervous about it. I stayed out of, for example, the genocide debate at the Yugoslavia Tribunal in terms of joining in the Milosevic trial. I think that some of the lawyers in those cases would have liked me to sort of take sides, and I've tried to stay avoid taking sides. And, you know, what do people think of me? I hope they think that there's something in what I say for both sides, because I think that is where an academic should be. I think you need to have that distance. So I've never actually been on either a prosecution or a defense team. I'm there as an expert consultant, you know. So occasionally they'll retain me to give them an opinion, but I say, look, I really don't think my place is being part of a defense team or the prosecution team, for that matter.
Obviously, you've written extensively, and just in the various tribunals, and ultimately you have to have a starting point in the tribunal history process. You got to know where you came from to where you are today. How much does Jackson and the Nuremberg trial relate to you, Bill?
It's Jackson and Nuremberg is huge for me, and I mean, you can check it out in my writing or when I lecture. It's really very, very central, because I mean, my first big book in the field of international criminal law is on genocide, and of course Jackson he used the word at the London Conference in 1945, but as you know, the charter of the Nuremberg Tribunal speaks about crimes against humanity, and of course that's the crime against humanity of extermination, which was, I think, if you'd ask Jackson, are you prosecuting genocide, he would say, sure, it's the crime against humanity of extermination. In fact, he did say it essentially during the London Conference in June and July of 1945. But I think that the story of international criminal law over the last 65 years, a big part of it has been what I call the relationship between genocide and crimes against humanity, which remains to this day. We have regularly, you know, quarrels about, is something a genocide? The term gets used, and then people say, no, it's better described as a crime against humanity, and then someone says, oh, only a crime against humanity. Of course, I don't think Jackson would have said only a crime against humanity. He would have said that's about it. So I think that the role of Jackson and that Nuremberg period is it's not only seminal in the sense of starting, it's the beginning, but it's also seminal in terms of framing the debates. Very, very important period, and now as our interest refocuses a little bit on crimes against peace and the issue of aggression, of course Jackson, of course, is very central to that as well. So he's a very important person in my narrative of international criminal law.
You mentioned the term aggression. You were at Kampala. For the layperson, what was the end result of that conference? Maybe you could back up a little bit for, again, pretend you're the professor and educate the audience as to you had the Rome Treaty, you had the creation of the International Criminal Court, the deferment, if you will, for the definition of aggression, and then there was this gathering.
Yeah.
Maybe I've overstated it, but.
Well, of course, you know, at the beginning in 1945, aggression was then called crimes against peace, although they used the term aggression at the time as well, was considered almost the glue that put the case against the Nazis together. That was the central theme, and then all the other atrocities were viewed as being associated with that kind of overarching theme of their big crime was waging an aggressive war. And that's been probably, that vision of international crimes has probably been changed over the years, so that we focused more on the specific violations and on atrocity crimes committed in peacetime or in civil wars, and so we've lost a little bit of that. And when the International Criminal Court was being created in 1998 at the Rome Conference, there was the list of crimes that essentially came from Nuremberg, Jackson's list, although it had slight changes in the terminology and definition. But we couldn't agree on whether to include aggression or crimes against peace in the statute of the International Criminal Court. And some, you know, there were many, including the big human rights NGOs, who said it's better not, just leave it alone. And then there were many others. I don't think they said it in the name of honoring the legacy of Jackson so much as, but it was very much that this was all a cohesive package back in 1945, and it had to be retained. So we went through then, after the Rome Statute was adopted, a dozen years of negotiating, trying to figure out whether and how aggression would be included within the law applicable to the International Criminal Court. And so the Kampala Conference did it. And I would say I was there from beginning to end. I would say until the last hour, you couldn't find someone prepared to bet serious money on it being included. It was a very surprising outcome. And I think we'll look back on it saying, well, it was surprising because there was so much disagreement about it, but that someone looking at the big picture would know that it couldn't have turned out otherwise, that it had to be included. But it really was quite, unexpected that it would be included. And maybe that was just because it was, like Victor Hugo said, nothing can stop an idea whose time has come, but it had to be done. But it was quite a surprising outcome. So whether it'll ever be prosecuted again is another question, whether it'll become a useful tool for prosecutors and be used by the court remains to be seen. But I think the idea of putting it back there on the list, making it clear that this is a central violation of international law, it can only have positive impacts for world peace, for the international community. I think I'm very happy about the development, and I think it's good for the court, which has been, it's been hurting, it's been struggling, the International Criminal Court. It hasn't developed and hasn't prospered as much as people had hoped. So here we are now, 7-8 years after it starts. They still haven't finished the trial. The trial they're supposed to start is not in terminal meltdown, but is still in having trouble.
Did they, in a nutshell, what is the definition of aggression?
Well, there are, like the other crimes, there are two pieces of it. So you have a contextual element, or a chapeau, which, if you were talking crimes against humanity, the equivalent would be the idea that it has to be a widespread or systematic attack on the civilian population. And then you have the list of acts. So you have a list of acts of aggression, which are, invading, blockading harbors, so on. There's a list that comes from a General Assembly resolution that was adopted in 1974. And then there is the contextual element, which says that aggression has to be, we're talking about the crime of aggression, so it says it has to be an act of aggression, which is a manifest violation of the Charter of the United Nations. And so the idea is that not all acts of aggression would be the crime of aggression. It's a more extreme version. And, so that's, it is quite a different definition. We didn't work with the definition at Nuremberg at all. Yeah. It's a different definition altogether, really, than what was used at Nuremberg.
As you write the narrative, and no doubt you have or will, at some point there's the raw politics of the coming to yes. What was the tipping point in the argument? Now that you saw and you said, gosh, I wouldn't have bet again. I wouldn't have bet it at all a day before, and all of a sudden somehow it happened. How did that happen?
Well, the big obstacle to reaching agreement over the last 12 or 13 years has been the resistance of the permanent members of the Security Council, the 5 permanent members, to allowing the court to operate without their blessing. And so the 5 permanent members have taken the view, sure, we can have a court that can prosecute aggression, but you can only do it when the Security Council authorizes it, gives you the green light. And they stuck to that position until the very last minute of the last hour, the 59th minute of the 11th hour on the Friday night before the conference ended. They were still stuck to that position. And on the other side, you had all the other states who really just needed to reach some kind of a compromise agreement, something they could live with. And it involved compromises on various, on the strength of how deferential the court would be to the Security Council even though they all agreed that the court would be able to do it without the Security Council. So you had the problem of the 5 permanent members of the Security Council, and that was settled when they just sat on their hands in the final, when the president of the conference called for a vote. And he said, does anybody insist on a vote? You had 2 people who could do it, France and Britain, because they are the 2 permanent members of the Security Council who are actually already parties to the Rome Statute. So they were, the other 3, China, France, and China, Russia, and the US, couldn't vote, so they couldn't call for a vote. Yeah. But France and Britain could, and they didn't. And they blinked, basically. They just decided that politically they weren't going to fight this one out. So it also, the adoption of the definition of aggression represents an adjustment within the, sort of the world order, in that it's a bit of it's a taming of the power of the Security Council, actually. And that's, what that means in terms of the future, I don't know. People, many states want to reform the Security Council because they want to have more permanent members, and they maybe want to eliminate the veto, but there's no way the 5 permanent members are going to give that up. So basically what you're doing instead is, rounding off the corners of the 5 permanent members, and I think that's what happened at Rome. And then, of course, you had to get the bulk of the other states to come to an agreement. And they were divided initially during the conference very sharply along north-south lines. So when we say the north, we include Australia, New Zealand, Canada, the US, as well as Europe. But essentially, those states had a position that was much more deferential to the Security Council. And then you had the states of the south, Latin America, Africa, who said they didn't want any role at all for the Security Council. So finally, they were able to reach a compromise. But it only happened at the last minute. It was great drama. And people were teasing me the morning of the final day. They said, you're an international law professor. They said, you don't really care what the result is. You just enjoy the drama and the theater of it all, which I think that's too harsh an assessment of my own view. But it's true that, as someone interested in international law, just being a fly on the wall watching this process is absolutely fascinating, and that's what it was at Kampala.
Was there an individual who actually brokered this?
Yeah, there were actually 3 key people who navigated the whole thing through. One was the president of the whole conference. His name is Christian Veneweser. He's the ambassador of Liechtenstein to the United Nations. And Christian is a very skilled diplomat and very determined. And he's from a tiny little country, but they clearly punch above their weight, at least in this area. The second one is Prince Zaid, who's the ambassador to the UN for Jordan. And they were sort of the 2 ambassadors, the team that did this and pulled this through. And then they had an assistant. Christian has his sort of deputy, was a guy named Stefan Barriga, who's more in the, Stefan is more, well, he's not an ambassador, he's an employee, and but he was central as well. So the 3 of them were really crucial. And, but, historic occasions produce great people who rise to the occasion. One of them, I don't know if if it's thinkable that someone from Liechtenstein could be the next Secretary General of the UN, but I wouldn't underestimate the future career of Prince Zaid, who's a charming and gifted diplomat and a very fine person, and he was very central to it.
Where was the United States in all this? I realize we're not a party to the Rome Treaty, but as an observer, were they in the game? Yes.
Oh, yeah. The United States had kind of, abandoned the battlefield, so to speak, in about 2002, and they'd stopped participating actively in these negotiations about the crime of aggression. The U.S. had been very active, of course, when the Rome Statute was being adopted, and the U.S. position is often distorted by people who present it as the U.S. was against the court, but the court overcame the U.S. opposition, or the other states did, and that's not true. The U.S. was a big supporter of the idea of a court. Finally, in 1998, at Rome, it didn't get the court that it wanted. There were things about the court that it didn't like, and that posed a problem for the U.S. And then during the first Bush administration, there was a period of quite open antagonism to the court. But that calmed down with the second Bush administration, and the U.S. became more and more positive about the court. So yeah, in the preparation for the Kampala conference, the U.S. was a very active player. Some of it was behind the scenes, and I've been told that the legal advisor Harold Coe did a tour of European capitals before the Kampala conference, saying to them, "We don't want a definition of aggression to be adopted. We prefer that doesn't happen." And he did this publicly as well in some speeches. And then the U.S. at the conference tried, with a limited success, to adjust the definition of aggression that had actually been pretty much agreed to before the conference. By, there had been a consensus on the definition. The real problem at the Kampala conference wasn't the definition of aggression. It was this issue of how the jurisdiction over aggression would be used, and the role of the Security Council. So nobody really wanted to go back and reopen the debate about the definition, except the U.S. And that was allowed to a limited extent, and the U.S. proposed what are called understandings, which is a kind of a soft way of adjusting a definition. It's not part of the formal definition, but it's something a judge would take into account in interpreting it. So the U.S. made a couple of proposals, made several proposals, in fact, and two of them found their way into the final version, and they were basically, the purpose was to kind of tighten it up just a little bit, and so that worked, and so the U.S. was there and actively participating. But of course, there was in the end there is a divide between the states who are in the court and those who aren't, and so the states who are in the court are the ones who make the decision, and ultimately the ones who aren't were on the outside when it came to that
was
final.
Israel there?
Yes, Israel was there, and Israel spoke a few times. Israel was watching it and keeping an eye on it. Yep. The Kampala conference was open to all, to observers, and the observers were all of the states who had been at the Rome conference. And in fact, in practice, anybody could be an observer if any state could, even if they hadn't been at the Rome conference. And that's because there's a sense that you're creating or adjusting, or there's an evolution in an institution that that is designed to be a universal institution, like the United Nations. And although it will only become that when most states join it, like the UN. I mean, there was a time, if you go back to 1945, half the countries in the world, well, half of them didn't exist, and then half of the ones that existed weren't allowed into the UN at the beginning. So, it was actually a small club that then, over time, became a universal club. And I guess it's only in the 60s the UN became truly universal. And that's what's happening with the International Criminal Court as well. So, it's very important that you have the engagement of the states that haven't joined the court. And so that's why they do participate actively. And I think a lot of states, not the permanent members, but a lot of the other states who aren't in the court, were also deeply concerned about the crime of aggression. Iran was there, and Iran played an active role. And in fact, one of the highlights of the conference, it's anecdotal, it's a war story, but it's a session that won't really be recorded in the records of the conference. But I was there. We sat around a room debating these understandings that the U.S. had proposed. And it became kind of a food fight, very dignified, of course. Food fight's not the right metaphor. I'm trying to think of the right way to describe it. But, it was diplomats discussing things very politely. But the participants, the active participants in the debate, were the United States, Iran, and China. And none of them are members of the court. And we all sat back there watching it, saying, hey, this isn't your court. But of course it was in a sense, and you could see they all had a great interest in making sure that the language in the statute was right. So, they were all there. Israel stayed out of that one, but Israel was there keeping an eye on it as well.
How interesting. Will the United States become a signatory to the Rome Treaty, and if so, when?
Well, I think eventually the United States will join the court. You know, the difficulty, a big difficulty in the United States is with all treaties is getting them ratified because of the constitutional requirement of congressional ratification, as Woodrow Wilson discovered to his dismay, you know, way back in 1919 with the League of Nations. And the U.S. with the major human rights treaties has had a delayed, there's been a phase where the U.S. sort of sits it out and then eventually comes round. So, you know, with the Genocide Convention, it was adopted in 1948, and President Truman went to Congress and said, would you ratify this? And it took 40 years. It was not until 1987 that Congress authorized the ratification. With the big human rights treaties, they were, when they were being negotiated in the early 50s, Eleanor Roosevelt, of course, was at the center of the negotiations in the late 40s and early 50s. And then when the administration changed and Eisenhower became president, there was a declaration, I think, by John Foster Dulles, who was then the Secretary of State, saying, look, we don't need these human rights treaties. We have something better in the United States, which is the Bill of Rights. And it was kind of a turning their back on what was still a very nascent period for human rights law. It's true, it took another 15 years even to agree on the text of the treaties within the United Nations. But the U.S. sat that process out. And I think even today, lawyers in the Department of State understand that that weakens some of the U.S. claims, because years later, of course, the U.S. did come around to it. Mainly under the Bush administration, actually. Bush, I mean, there were three of them. The first, Bush 41, the first George Bush administration from 88 to 92. And Bush actually pushed through three of the big human rights treaties through Congress, and they were ratified. And so the U.S. for the last now almost 20 years has been bound by these three important human rights treaties. And I think there is still an understanding that the absence of the U.S. during the negotiation process hampers the ability to make certain arguments. But look, that's the way the United States has behaved in the human rights treaties, and it's the way it did in the court. And there was a sense at Kampala, and this was expressed by Harold Koh, the legal advisor, and Stephen Rapp, the ambassador for war crimes, in different ways. There was an understanding that they couldn't reopen everything about the debate about aggression because they hadn't been part of the negotiations, and you can't boycott a negotiation for 7 or 8 years and then show up saying, now we'd like you to reopen everything, you know. And so the U.S. lives with this, you know, hot and cold approach to negotiating and ratifying treaties. But to the extent that the International Criminal Court is kind of an inevitable part of the universal world order, like the big human rights treaties, the Covenant on Civil and Political Rights, whose negotiations the U.S. boycotted in much the same way. The U.S. ratifies it in 1992. It's almost, I think there are 165 countries that have joined that treaty now, out of 192. So it's almost universal. The UN, of course, is essentially universal, with Switzerland joining in the late 90s. It really covers the whole world now. And that's the future for the International Criminal Court. So it means, you know, the U.S. will have to be a part of it at some point, but it'll take a few more years. This is not going to happen very soon.
We've got Yugoslavia, Rwanda, Cambodia, Sierra Leone, all have different sort of titles behind them, but ultimately, whether it's a hybrid, ad hoc, whatever, their term is going to come to an end at some point. Do you see, from just generally the experiences of those 4 tribunals, and I may be missing one, whether that becomes a template for other tribunals, or is that sort of maybe run its course?
I don't think we know. I think it's too early to predict what's going to happen with the future of international tribunals. after the International Criminal Court statute was adopted in '98, I think there was a sense that, you know, the future was having one big universal institution, and that we wouldn't need to create ad hoc, you know, institutions and with their own, sort of creatively tailored to the situation where where justice was to be delivered. And I think had the International Criminal Court, been more successful and more robust and more in the first 7 or 8 years of its operation, that argument people would say, well, yeah, it's clear. But, you know, there was an example, I'll give you an example. 5 years ago, there was a report produced in the UN to deal with Darfur. It was the chair of the committee that drafted it was Antonio Cassese, who was the first president of the International Criminal Tribunal for the former Yugoslavia. And it was at a time when we were discussing what to do with how to bring international criminal justice to bear on the crisis in Darfur. Mm-hmm. So at the time, the U.S. was still fairly lukewarm, maybe lukewarm is even being too generous, towards the International Criminal Court. So the U.S. was taking the position, we're talking January of 2005, was saying, this isn't for the International Criminal Court, this is for another ad hoc type tribunal. And that was the position being taken by the U.S. The Europeans and others in the Security Council followed this report, which said, don't go to another ad hoc tribunal because they're too slow and cumbersome and it'll take too long. Go to the International Criminal Court, which is lean and mean and efficient. That was January of 2005. So the pro-International Criminal Court people carried the day in the UN. I mean, it was politics, of course. And the U.S., and this was one of the first signs that U.S. position was evolving towards the International Criminal Court, the U.S. could have vetoed that. But finally it abstained. And in effect, when the U.S. abstains in a resolution at the Security Council, it's as good as a yes vote because they're letting whatever it is go through. They're kind of reserving their view politically, but they're letting it go ahead. And so that was the decision. That decision was taken in March of 2005. Mm-hmm. But finally, the International Criminal Court hasn't been very effective in dealing with Darfur. It makes noise. It's made a lot of noise. The prosecutor's good at it, and he denounces and complains and howls in outrage, but not much happens because of the politics of the situation. And the question is, you know, looking back, it's hindsight, of course, but if in 2005 we had have said, followed the U.S. position and said, yes, why don't we give this to an African court or an African-inspired court or something, some new creative version of a temporary ad hoc tribunal, would we be further advanced with international justice in Darfur? Well, nobody will know the answer to that, but I think that if you put that on the table, people would scratch their heads and say, yeah, maybe we should have done that. And so I'm not prepared to rule out the idea that in the future we'll be looking for more ad hoc type tribunals that that in fact they're lean and mean compared with the International Criminal Court, which so far has shown itself to be an awkward, clumsy, kind of a blunt instrument. Mm-hmm.
I know you're about ready to say it's time to eat, Greg, but
it's time to have a drink, actually, before dinner.
Yeah. Oh, that's happy. But I always like to ask the question, here you are at this conference, first time here at the International Humanitarian Law Dialogues. Is there anything you hope to get out of this?
For me, it's a very, it's a fine opportunity to meet people. I think I'll know everybody here, the prosecutors and the academics who are here, to take stock of the Kampala conference, to talk about the big issues, to pick up a little bit on the the gossip and where things are going, and to test my ideas, which are always they're always in flux. I mean, I'm always thinking new and often unconventional thoughts about international criminal justice, and so it's I need places to try out my ideas, and Sometimes they get shot down and I bury them and forget about them, and sometimes no one can shoot them down. Sometimes people don't always leap with enthusiasm and say, you figured it out. But I watch that balloon out there and I wait to see if someone can take aim at it and shoot it down, and sometimes they can't, and then I move forward with developing it further. So that's what a conference like this does, and I do a lot of conferencing. It's part of my job as an academic and someone who's writing and studying these things. So these are always beneficial. But I'm excited about being here. I think the venue of Chautauqua was lovely, and I'm really looking forward to going to the Jackson Center as well and seeing that.
Look forward to having you here, Bill. Thank you. Thank you very much. I need to have you sign your little biography.